Hello, everyone. My name is Kenneth Gray. I'm a consultant in the Banking and Finance Department of Norton Fulbright in London. And in this video, we're going to be talking about the recent case of Virgin Australia and Wells Fargo and how the Cape Town Convention has impacted on that case. And in this video, I'm going to be accompanied by the partners Noel McCoy in Sydney, where the case was heard, Mark Craggs in London, and David Rosenzweig in New York, and they will be giving us an analysis of their laws and how they are impacted by the case. Firstly, if I could just address the Cape Town Convention briefly. It's a fairly recent convention. It came into force in 2006. It deals with the rights of creditors in respect of aircraft objects, so mortgagees or lessors, and it's now been ratified by over 80 different jurisdictions, including, of course, Australia, but also the United Kingdom and the USA. And this case is particularly important because I think it's the first time that a case involving Cape Town has reached such a high appellate court. So having said that, I'm going to hand over now to Noel to take us through a bit what happened in that case. Noel.
Well, thank you, Kenneth. So the Willis case arose out of the Virgin Australia administration. That case arose after the end of the 60-day waiting period provided for under the Cape Town Convention. During that period, there's a moratorium where lessors and secured creditors are unable to take possession of their aircraft objects. But at the expiry of that period, Willis asked for the return of its aircraft objects. On the other hand, the administrators were prepared to facilitate that, but only to the extent of saying, in effect, here is your aircraft objects, by issuing a notice under local insolvency law, section 443 of the Corporations Act, which expresses an intention not to exercise any rights in respect of leased property. So on the one hand, Willis was requesting return and redelivery of its aircraft objects, specifically its 4 CFM International engines for use in Boeing aircraft, to its place specified in its lease in Florida. On the other hand, the administrators indicated that Willis ought to collect its aircraft objects from Australia. And so the battle lines were drawn. In the first instance, Willis was successful, but then on appeal to the full court of the Federal Court of Australia and then to the High Court of Australia, our ultimate appellate court, the court sided with the administrators and ultimately found in respect of the give possession aspect of Article 11 of the Aircraft Protocol that give possession means for the administrators to take whatever steps may be necessary to provide an opportunity for the exercise of the right to take possession. In other words, as I understand it, the High Court is indicating it's the administrator's role to facilitate an outcome which enables the lessor or secured creditor to come and take possession of its aircraft objects or its secured aircraft objects. And so the responsibility and cost lies with the lessor or secured creditor and does not lie with the insolvent estate. And so that outcome very much rested upon an interpretation of the language, not just of Article 11, but of the Convention and the Aircraft Protocol taken together, and creates a situation where, as I mentioned, it will be important for administrators to play a facilitative or coordinative role in facilitating repossession, but it will not be generally at the cost of the insolvent estate, and in particular, the more onerous parts of redelivery will be at the cost of the lessor. With that said, the test that has now been provided by the court provides some clarity, but not complete certainty, particularly in terms of the factual matters that might be faced by a lessor going forward. For Willis, that has been fully resolved in this case, but for other lessors, what specifically might be required as a matter of practicality is yet to be determined.
Thanks, Dale. That's really quite interesting. And I think one point we need to make is that by its terms, the Cape Town Convention is required to be interpreted and applied consistently in all the contracting states. So the decision of the High Court in Australia there will have very significant persuasive power before courts in, well, we've mentioned the USA and the UK, but also China, Indonesia, India, Brazil, all the other 80 jurisdictions that have ratified the Cape Town Convention. So it's a pretty important case. Mark, turning round to you now, can you maybe give us a few thoughts about how that case, what the consequences of that case would be in the UK, in England?
Sure. Thanks very much, Kenneth. So from a UK perspective, and I suspect in a number of other jurisdictions as well, there's an important distinction to be drawn between the ramifications of the decision in a terminal insolvency type scenario and in the context of formal restructurings. Now, I think it's important to view the decision too as very much one on the interpretation of Cape Town and the lack of additional remedies under the convention. I do think it is still necessary to have regard to the underlying terms of the lease. So just in terms of that distinction I referred to, for a terminal process, I think the decision marks a recognition of the reality really of what could be a heavily insolvent airline with very many creditors potentially whose claims won't be paid. And against those circumstances, it's quite easy really, I think, to see the prejudice that might be caused by requiring insolvency office holders to adhere to ever more complicated and expensive return conditions. Hence, I think really where the High Court came out in terms of if you want it, come and get it kind of outcome. So that's the sort of dark side solution, if I can put it like that. On the more kind of glass half full and restructuring properly so-called side, there's a related point really, that because financiers and lessors will fare less well in an insolvency scenario, the bar is commensurately lower for the comparator, certainly in the UK, in a scheme or restructuring plan scenario. So practically what it means is that it now should be easier to get a restructuring away. And in particular, because lessors won't receive the benefit of any aircraft return repatriation in accordance with the lease, but will be left with an unsecured damages claim for any losses arising from non-compliance with the lease. It will normally be easier for the debtor to demonstrate that the deal on offer for them in a scheme or restructuring plan scenario represents a better outcome than they would get in the counterfactual or relevant alternative, as it's known in the restructuring plan context. So in a nutshell, that's how I see it from the UK perspective.
Thanks, Mark. It's very interesting. David, the aircraft protocol and Article 11 of the aircraft protocol was obviously very closely based on Chapter 11. So it'd be quite good to hear some reflections from you as to how it compares to Chapter 11 when actually put into practice.
Thank you, Kenneth. Yes, in the US, we have adopted the Cape Town Convention, but not Alternative A. And that's because, as Kenneth mentions, the US has adopted Section 1110, which is what Alternative A was modeled after. So Section 1110 dates way back to 1978 with the original enactment of the current US bankruptcy code. Many US airlines, as we all know, have filed Chapter 11, and courts have considered various issues under Section 11, including the issue of the type of return that must be accomplished by the airline. Now, Section 1110 uses different language. It uses language regarding the airline's requirement to surrender and return the equipment, slightly different than the Alternative A language, but in the same general genre. Lessors and lenders here in the US cases historically did push for a similar outcome as Willis did in the Australian case. That is, returns in compliance with the lease or the contractual redelivery obligations. But the US courts have more or less landed now on what is known as a test of reasonableness, not compliance with the agreement, but a reasonable return protocol that the airline must accomplish. but it's not the redelivery obligations in the lease. So as a result, what we see in the US cases is more or less the lessors and financiers work out an agreed protocol with the airline on how the equipment is to be redelivered in the case of a rejection of the lease or an abandonment of the collateral. But it's tempered by the circumstances where the courts will not require compliance with the lease terms. Now, that doesn't mean that the damages that exist for non-compliance disappear. What happens is the lessor or the financier has a claim that it can assert in the case for damages for the failure to meet the return conditions, the costs of transporting or storing the aircraft. Those all go into the claim, but they're put aside for a later date. The courts have basically said, I think consistent with what the High Court in Australia noted, that the purpose of Alternative A or Section 1110 is one of speed and ability of the financier to get its collateral back without the hindrance of a moratorium or a stay in that circumstance. What I would say is on the High Court's decision itself is, one, it's not really inconsistent with Section 1110 law, but where they stopped short was perhaps not incorporating the reasonableness standard and simply just have what is now a flat statement that compliance is not required, at least lease and return condition compliance are not required, but they didn't put any substance to what is really required and at least provide a reasonableness standard. That may have to come in future cases, perhaps in other jurisdictions.
Thank you, David. Yeah, that's very interesting because obviously this was the first case heard relating to the Cape Town Convention. We would expect as more cases come before the courts and that jurisprudence will be built up. I think what this case does actually, it really shines a spotlight on the fact that, on the insolvency of a lessee, lessors have a variety of remedies, and some of those are affected or bolstered, improved by Cape Town, and some aren't. But those that aren't still remain subject to domestic insolvency laws. It's not as if they disappear. They're still available, but they're just governed by whatever your domestic law will say. I think that's all that we have to say on this video. If anyone watching this has any questions, then please feel free to contact any of the panelists. You can find our contact details on the Norton Rose Fulbright website. Thank you very much.